Good afternoon, everybody, and welcome to the weekly press briefing of the Kosovo Specialist Chambers, where we aim to provide journalists with an update on the latest developments at the court and the opportunity to ask questions. I would like to begin with a remark in response to misleading and incorrect media reporting and to statements made by the Kosovo Ombudsperson on a report prepared by the Bar Human Rights Committee of England and Wales, the BHRC, which was commissioned by the Office of the Kosovo Ombudsperson. Contrary to recent media reporting, the BHRC report contains no finding that any decision by Specialist Chambers judges has violated the human rights of any accused, nor does the report conclude that the Specialist Chambers jurisprudence violates or conflicts with the case law of the European Court of Human Rights or any ad hoc international tribunal, including the ICTY. The BHRC report equally makes no finding that decisions on pretrial detention have breached any human rights convention. In fact, the report reflects on the effective availability of judicial remedies before the Specialist Chambers and notes that many issues are still pending before the judges and may be appealed before higher instances. It should further be noted that many of the points raised by the Kosovo Ombudsperson and examined in the BHRC report mainly reflect arguments drawn from defense submissions. They do not engage with the positions of the prosecution or victims' counsel, nor with the specific reasoning of the panels in their respective decisions. The report itself acknowledges that many of the issues it addresses remain subject to ongoing litigation and are therefore still to be determined by the judges. The Specialist Chambers takes this opportunity to recall the distinct roles of the parties before it. The defense represents and protects the interests of the accused in the proceedings. Victims' counsel represents and protects the interests of participating victims. The prosecution bears the burden of proving the charges it has brought. And it is the trial panel alone that determines the facts, evaluates the evidence, and decides whether guilt has been established beyond reasonable doubt. Any of these decisions may be appealed. A fair and accurate understanding of the Specialist Chambers' work therefore requires careful attention to the full reasoning set out in the judges' decisions, not only to the positions advanced by any one party. It is also important to note that neither the Kosovo Ombudsperson nor the BHRC has any standing before the Specialist Chambers, and that the report will not have any effect on the work of the court. Turning now to the developments in the cases before the court. In the Thaci et al. Trial concerning alleged war crimes and crimes against humanity, the trial panel on 5th May issued an order extending the deadline for the pronouncement of the trial judgment by 60 days, namely until 20th July 2026. The panel found that the circumstances of the case require additional time, citing the volume of evidence and the complexity of the proceedings. I want to be clear that the 20th July is not the date for the pronouncement of the judgment itself, but only the date of the extended deadline by when the trial judgment would be issued. The panel highlighted that, should a further extension be absolutely necessary, it will issue an order to that effect in due course. In the trial of Hashim Thaci, Bashkim Smakai, Izni Kilay, Fadil Fazliu, and Hayreddin Kuchi on the alleged influencing of witnesses, the last witness in this case, called by the Thaci defense, is expected to testify during the week of 11th to 15th March. This was announced in a decision issued by the single trial judge on 29th April, which became public on 4th of May. In that decision, the single trial judge directed the defense to close their cases by Thursday, 14th May 2026, adding that the defense will be permitted to submit additional evidence depending on the outcome of an appeal on specific evidence the prosecution has requested to be admitted. The single trial judge further ordered the prosecution to file requests for the admission of any rebuttal or rejoinder evidence by no later than 15th May. The single trial judge also informed the parties that they must be prepared to file their final trial briefs by Friday, 19th June, with closing statements to be held 21 days thereafter. The single trial judge highlighted that confirmation of these dates depends on the outcome of some interlocutory appeals that are still pending. On 1st May, a decision of the single trial judge dated 27th March became public, in which he rejected a request by the prosecution to admit a report from an expert witness who had testified in March this year. The witness had refused to answer certain questions about his methods on grounds of confidentiality. The single trial judge found the report inadmissible as the methods applied were not sufficiently transparent to permit a meaningful assessment of its probative value. The judge concluded that admitting the report would be prejudicial to the defense and rejected it accordingly. The single trial judge did, however, admit the testimonial evidence of the expert witness. In the same decision, the single trial judge granted a request by the defense teams of Mr. Kilai and Mr. Smarkai to increase the word limit for a joint motion related to the expert report, noting that the prosecution did not oppose the request and that it fell within the total applicable word limit had each defense team filed their responses separately, as they were entitled to do. Also on 1st May, a decision dated 22nd April became public, in which the single trial judge rejected the admission into evidence of an expert report that the Thaci defense had sought to introduce as a standalone exhibit, not linked to any witness testimony. The single trial judge found it inappropriate to admit the report into evidence because it addresses the legal interpretation of the very provisions of the Kosovo Criminal Code that are to be applied in the present case. The single trial judge drew a clear distinction between expert reports which may address questions of fact or of foreign law and the interpretation of the applicable law, which falls exclusively within the province of the judge. Also on 1st May, a decision dated 14th April became public in which the single trial judge granted Fadil Fazliou's request for a variation of the conditions of his release, permitting him to resume contact with his son Fari Fazliou. The single trial judge recalled that the contact restriction had been imposed because of the risk that Mr. Fazliou might influence his son, inadvertently or intentionally, who could in turn contact potential defense witnesses. In view of the single trial judge, several procedural developments have since substantially reduced that possibility, and the reasons underpinning the restriction therefore no longer exist. On 4th and 5th May, decisions of the single trial judge dated 12th February and 23rd March became public, granting in part a request by the prosecution to admit evidence as standalone exhibits not linked to witness testimony. The single trial judge admitted those exhibits that were found to be relevant to the case, authentic, and not prejudicial towards the defense. On 5th May, the single trial judge granted a request by Mr. Thaci and authorized him to attend hearings for the presentation of the defense case via video conference. All accused have now been authorized to attend the hearings via video conference. Finally, in the case of Piotr Shala, the president of the Specialist Chambers, President Ekaterina Trendafilova, on 1st May assigned a Supreme Court panel to decide on the defense request for protection of legality against the decision on the defense appeal against the reparation order. The panel consists of Judge Ekaterina Trendafilova as presiding judge and Judges Christine van den Wijngaard and Daniel Franzen. That was all from me. If there are any questions, I'll be happy to respond.